What is criminal intent and why do we have to prove it? Welcome back to our Understanding the Justice System series. Today, we're exploring criminal intent, which is one of the most critical but frequently misunderstood elements in criminal law. I often hear community members asking why certain crimes are not charged at higher felony levels. While these crimes can be devastating, as prosecutors, we cannot let our emotions guide our decisions. We are bound by Missouri law and must adhere to specific legal standards which govern how we charge cases. Prosecutors have a duty of proving all elements of a crime beyond a reasonable doubt. One of those critical elements is criminal intent. Intent reflects the defendant's mental state at the time the alleged crime and is essential to determining the appropriate charges. But proving what someone was thinking can be challenging. Since we can't directly observe another person's thoughts, Missouri law recognizes 4 levels of criminal intent, each carrying different legal consequences. As prosecutors, we apply these 4 levels of criminal intent to determine the appropriate charges in a case. The level of intent directly corresponds to the severity of the charge we can pursue. More serious crimes like first-degree murder require higher levels of intent, while less serious charges may only require proof of recklessness or negligence. For most offenses, we are required to prove purpose or knowledge, but for some lesser offenses, we only need to prove recklessness or negligence. Number 1. The highest level of criminal intent when someone acts purposely, which means their conscious goal was to cause the specific criminal outcome. In other words, they had the goal of obtaining a certain result. Very few offenses require that we prove purpose. Number 2, the second level of criminal intent when someone acts knowingly and they are practically certain their actions will cause the criminal outcome, even if causing that outcome was not their primary goal. This is the mental state required by most statutes, including murderers. For example, if a person shoots repeatedly at a crowd, they may not have the purpose of killing a particular person, but it is practically certain that they will kill someone. In addition to normal issues of criminal intent, murder has 2 special and opposite mental statutes. The first is deliberation, which is sometimes referred to as acting in cold blood or cold-blooded. Deliberation means that a person calmly thought about killing a person, and people can deliberate simply for a second. For example, if someone purchases a gun, writes something threatening to the victim on social media, goes to the victim's home and shoots them, the evidence here shows that they thought about killing their victim. Murder in the first degree requires deliberation. If we are unable to prove deliberation, the murder is in the second degree. The second is sudden passion. Sudden passion means that the person acted immediately in response to some provocation and did not stop to think through their actions. Number 3 is a lower level of intent, recklessly, which means that a person consciously disregards a substantial and unjustifiable risk that their actions will cause harm. And that disregard represents a gross deviation from what a reasonable person would do. For first-degree involuntary manslaughter charges, we must prove that the defendant recklessly caused another person's death. A recent case we charged involved street racing, where a defendant allegedly crashed into an uninvolved vehicle, killing 2 people. The racer knew the substantial risk, but chose to race anyway, consciously disregarding the danger to others. We also charged a man whose toddler fatally shot himself after a man failed to secure his loaded firearm. While the defendant in these cases did not intend to kill anyone, they display a higher degree of recklessness. And number 4, the lowest level of intent is negligently, which is when a person should have been aware of a substantial risk, but failed to perceive it, which represents a significant deviation from reasonable care. We would apply this rule to second-degree involuntary manslaughter, which requires proving that the defendant acted with criminal negligence in causing death. These cases involve a lesser degree of recklessness. Again, As prosecutors, we must evaluate cases and carefully analyze what the evidence tells us about the defendant's mental state. We cannot charge at higher levels than what we can prove beyond a reasonable doubt. Understanding intent ensures fair charging decisions based on evidence, not our emotions or bias, and it protects against convicting people, for accidents.